Bunch of viewers on, and we're going live. We've got a bunch of viewers waiting on YouTube. Here we go. Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, just as yesterday, I've got two people joining me today. First up, Mike Piwowarski, fresh off his run on the Rundown, and Alex Ooley from the Ooley Law Offices in Indiana. The reason I wanted to bring Alex in today is because Alex is our law guy. When there's a law question or discussion that comes up, I always want to go to Alex to get his opinion, his take on it. Alex, boy, did we get a law issue come up today. We had the Supreme Court come up with the NYSRPA versus Bruen decision. Could I have you, as I'm getting social media hooked up, could I have you give us a little bit of a rundown, starting with Thomas wrote it, right?
Yeah, not only did we have a legal discussion come up today, we had some good news come from that discussion. As you alluded to, the decision in New York State Rifle and Pistol Association versus Bruen came from the Supreme Court today, and Justice Clarence Thomas wrote the majority opinion, which we had been hoping for. We'd been speculating about who might write it, and in fact, today was Justice Thomas's birthday, so that's another interesting timing wise there. So it was a great outcome. We knew that it would be a win, or thought that it would be. We just didn't know the extent of it, and it was a very good opinion in lots of ways. For those who don't know, I'm sure most listeners do know that the case was about New York's May issue licensing regime and the requirement that someone who wanted a license in New York had to show a special need, and that was a need beyond the general need to have a firearm for self-defense. So you had to show some special need greater than the general population that you needed, like this firearm for some particularized purpose, some special need that was specific to you. And I think this was clearly unconstitutional, and the court decided that it was, and issued their opinion today. It was a 6-3 opinion, so Justice Thomas was joined by the other conservative justices. Justice Alito wrote a concurring opinion, joined the majority opinion, but noted a few other issues that he thought should be addressed. And then Justice Kavanaugh and Justice Roberts also wrote a concurring opinion, and Justice Barrett also wrote a concurring opinion as well. So obviously that leaves Gorsuch, who joined the majority but didn't write a concurring opinion, didn't write separately, and then Justices Breyer, Sotomayor, and Kagan, who dissented. So it's great news, and we can get into some of the particulars, but the gist of it is that the Supreme Court struck down New York's May issue licensing regime, and it's likely to affect some of the other states that have a similar regime.
Yeah, top of mind, New Jersey, Massachusetts, California, Hawaii. There are more, but those are the ones that come immediately to mind of the May issue. There are 7 of them, and those are the ones that come immediately to mind.
Yeah, and for people who don't know, there's basically 3 different types of handgun licensing styles, I guess, or regimes. And there's the permitless states. Obviously, there's this talk around constitutional carry. Mm-hmm. I prefer to call it permitless carry, but often call it constitutional carry interchangeably. Then there's states that are shall issue, that is, if you meet certain objective requirements, you don't have a felony record, you don't have mental health issues, various other objective requirements, that as long as you meet those, the state will issue the license. And then there's the third type, which is what New York had, which was a May issue licensing scheme, where even if you met certain objective requirements, whether or not you received a license was up to some bureaucrat who had discretion to issue the license based on whether you could show some special need.
Now, let me ask this, and Mike, feel free to chime in. I personally, if I lived in New York or New Jersey or Massachusetts or any of these states that are Up until today, we're May issue. I would not go out tomorrow and apply for a permit. I would give it a few weeks for things to settle out and to find out what's going on. But I would not probably rush out tomorrow and go do it.
Yeah, and let's
Paul,
face it.
I'd probably do it tonight.
Oh,
yeah.
Yeah, Paul, I would probably do it tonight. You know, they go into Judge Thomas went into when looking at the history, and I believe we saw it from Judge Alito as well. They discussed the history of bearing arms when they looked at the historical evaluation, and made the comments that bearing arms was always designed to be, that of openly carrying firearms. They did discuss in the historical evaluation again that it wasn't typically the underclothing carrying. So they basically said the history of carrying arms was an open carrying of arms. They didn't get too much into it beyond that, but my belief would be, because we still have a couple of states out there that have no open carry, no open carry of any kind, and many states have open carry. So if maybe my brain's jumping too far into it, but if I go out today to New Jersey and apply, and they tell me I cannot carry concealed, well, the Supreme Court has just told me I have a right to carry and explained both types of right to carry. So if I'm told by my state I cannot conceal carry, well, Supreme Court says I have a right to carry, so I must be able to open carry.
Yeah, this case is obviously going to open up a lot of different issues with respect to sort of time, place, and manner restrictions. So,
right.
One of the issues that came up in oral argument and again in the written opinion was what sorts of restrictions could be put on where you carry. And so I think what a lot of states like New York will try to do here, even though their licensing regime has been struck down, I think they will try to name every place they can as a sensitive place. So whether that's New York City as a blanket sensitive place, I don't know what they'll try to do in that regard, but certainly New York will try to infringe on the rights of gun owners as much as they can. And that's something that will have to be litigated in future cases.
Well, as far as New York goes, I mean, that was clear. Thomas, went over that example almost to preemptively, shut that down, saying that that New York could not preemptively declare the entire entity of Manhattan as a sensitive place, that it must be those that have traditionally, and quoted Heller and Scalia, and said that those that normally traditionally off limits places that you would have. The typical things that we see. And now we know they vary from state to state, but it's your hospitals, prisons, police stations, places like that. And just because of the amount of people that gather or the location of the gathering, they cannot call that a sensitive place and have it done. And that was something that, again, he clearly called out Manhattan as the example and said, you can't do it.
Yeah. You're right. He preempted that issue, but and you mentioned the history. That was another important issue that came out of this decision is how do you evaluate these sorts of restrictions on Second Amendment rights? And we were talking in previous podcasts or previous shows about how the Supreme Court would address that issue because, as you know, in Heller and McDonald, the court didn't specifically address that issue, but the court nevertheless evaluated the laws that were challenged in those cases under text, history, and tradition. But nevertheless, appellate courts since that time have tried to apply lower levels of scrutiny to Second Amendment challenges. And so the Bruen case settled that matter and said that the Second Amendment is not subject to interest balancing. There is no intermediate scrutiny, not strict scrutiny. Rather, the courts in evaluating these sorts of restrictions should look to text, history, and tradition. So if the state of New York does try to put additional sensitive place restrictions on the right to keep and bear arms, those sorts of restrictions will have to be evaluated under text, history, and tradition. And so they'll have to look to the history to see whether or not those sorts of restrictions would have been historically within the realm of the Second Amendment.
Yeah, and the justices were very, very clear on it too. I mean, calling it the new one-step test, right, based on the history of the text. And we all know sitting here, and as many watching us, that for the most part, a lot of these states ignored Heller and they ignored McDonald, and the justices this time around, all of them that cited along with the concurrence here that's not going to happen again, or they don't want that to happen again. They went back and reiterated and specified. In fact, I think it was Kavanaugh made 2 points, and his entire second point was to quote Scalia from Kavanaugh, or from Heller. This is what we said in Heller, and this is what we meant. So it was real nice to see after. What are we looking at? A 12-year break that we've heard from the court on a Second Amendment case, for them to come out so strong and so specific with their "this is what we mean."
I want to get a couple comments in here real quick. And first one, great question from DJ Playnice. What about cities in other states with open carry preemption? I
hope I didn't confuse. I'm sorry, Paul. I hope I didn't confuse when we're talking about open carry. It's just, I think that's one of those little things that we might see come on the tail end of this. This clearly says that that carry shall be allowed under the shall issue shall be the most scrutinous method possible. And again, all that means is as long as you're not disqualified, you'll be certified to carry. Mine was one of those what if questions. So if you are able to carry, they're going to let you carry. So it's, Florida happens to be one of those states. Why? The reason we don't have open carry is because we allow, concealed carry for those qualified. And I think as long as you have a method available to you, then you're okay. So my question was more of that theoretical, if I can go apply before they change their laws to shall carry, then they'd have to let me open carry.
Yeah, that's right. This case didn't decide the manner in which you were to carry your firearm, whether it be open or concealed. Right. It simply held that New York's proper cause requirement violated the 14th Amendment, and that it did so by preventing law-abiding citizens from exercising their right to keep and bear arms in public. So that was the key holding here. And just to make a little bit more sense, maybe it's useful to give a little background. So Heller in 2008 was decided that the Second Amendment protected an individual right to keep and bear arms in the home. And McDonald in 2010 extended that to apply to the states. So Heller was decided with respect to the District of Columbia, which was a federal enclave. McDonald extended the Second Amendment and incorporated the Second Amendment to apply through the 14th to the states. And now the Bruen case extends the right to keep and bear arms from the home to carrying in public, which is consistent with the plain meaning of the Second Amendment, the text, the history, and the tradition.
And I want to make sure that we touch on that, and that's the moving of the my brain isn't working here. The moving of the level of scrutiny that is put on future legal decisions in the lower courts to text, history, and tradition. Previously, it's been kind of whatever the lower courts have decided they want to put on it.
Right.
And with this ruling, it's now, I think going forward, this is going to put, if it's a Second Amendment case, it's going to force lower courts to go to text, history, and tradition. That's what my non-legal eyes read this morning. Am I off base there, Alex?
No, that's exactly right, Paul. And that was Justice Thomas provided that guidance clearly, and that's what a lot of the courts were wanting, and a lot of people on both sides of the issue were wanting, was some clear guidance about what sort of lens these cases should be evaluated through. And the court couldn't have been any more clear about that today when they issued the opinion, saying that they explicitly reject any interest balancing, even strict scrutiny. So a lot of the lower courts were applying a lower level of intermediate scrutiny, or really rational basis, but the court rejected any interest balancing approach and said that you should take this one-step approach rather than an interest balancing two-step approach, and you should apply text, history, and tradition.
All right, let me get this comment in here real quick. Speaking of restricted places, we had a comment over the YouTube side. Here in Washington, there's locations that have been restricted, such as protests, I believe. And at some point, I think New York is going to put... there's going to be something ridiculous in New York, and something like within 5,280 feet or 1 mile of a school. And if you've ever been in New York City, you know there's a school every 700, 800 feet or so. I mean, they've got 1 million schools for 5 million residents. Or however many residents are in New York. They got, no kidding, hundreds of thousands of schools. So
I think a lot of them are going to, like you said, they're going to challenge. We're going to see this come to a lot of back to local courts. Again, I think the good thing that we saw from Justice Thomas is that the preemption there when he was talking about Manhattan. New York, Washington State has the protest. Every state's got different places where your firearms you could carry are allowed differently. We know that. And that's why we always say when you're traveling from state to state, make sure you understand each state's laws. That's going to continue, whether, and the only way those are going to be solved is through your state Supreme Courts, to find out if those places are legal to ban. We have a little more guidance now from Justice Thomas saying, what historically has been is probably where you should be going, or places that you can get clear guidance on, or clear evidence on where it should not be carried. So we'll see, and I think you're going to see a lot of those challenges all over the place. The one that I'm looking forward to, the one that I want to see that I think is going to come out of this, Paul, Alex, you're there in Indiana, Paul, you're up there in the southern Canada, and you're both. I'm sorry, here in South Dakota. Those places right there, gentlemen, are both outside my home, and I was just told by the Supreme Court I could carry my firearm with a license, a shall issue license, outside my home.
And that's that. You just touched on that. I want to know where reciprocity goes, because I have a South Dakota license. I would love to be able to go spend tourist dollars in Manhattan. I would love to go see the Empire State Building. I would love to go to Washington, D.C. I'd love to see the Washington Monument. I do not want to have to spend all kinds of money and all kinds of time getting a non-resident permit for these places, although I would do that, but in several instances, you just can't.
Paul, I'm like you, a world traveler, and I want to country national traveler. Want to continue to have my Second Amendment right with me wherever I go. And Alex, I love listening to your interpretations. You say something, I'm like, damn it, how did I not think of that? Oh, that's right, I'm not a lawyer. That's why. But I'm curious what you think. Their absence of addressing that at all. Do you think that's on purpose? So that is the next thing that can be addressed from this?
Yeah, I think it was intentional, and I don't mean that it was intentional in a bad way, because the courts have a tendency to decide cases as narrowly as possible. Right. And by that, I mean, they try not to address issues that are not raised in the substance of the case itself. So sometimes courts will opine about issues that they think may come up in the future, but a lot of times those sorts of opinions, or that sort of speculation in an opinion, is simply called dicta. It's things that are not essential to the opinion, and we saw some of that in this opinion. There was some language in the opinion that wasn't essential to the holding in the opinion. So I think leaving those things out was more a function of the court trying to decide the case narrowly, because they try not to decide cases based on facts that are not before them.
I want to kind of switch a little bit here. We're still staying kind of on topic, but I want to switch gears a little bit. And oh, by the way, if you're watching live either on Facebook or YouTube, you can get your comment up. And if it's pertaining to what we're talking about, we'll certainly get it on the air and discuss it. But either comment on the live Facebook or live YouTube video, or if you have a Twitter account, it'll get here faster if you tweet with the hashtag Bullet Podcast. Have either of you two been watching on social media, the left is having an absolute total meltdown today. It's delicious.
Yeah, I saw the governor of New York come out and say that it's now going to be the Wild West. Anybody can carry, criminals can carry. The way this reads, and it's just to listen to the lies that they put out to try and stir the emotion. First off, I love the Wild West analogy, because that's every time any new gun law is opened back up for gun rights. That's their first complaint. So yeah, they're coming out with lie after lie after lie. How convicted murderers are going to be able to carry guns in prison or something.
Yeah. Well, and speaking of hyperbole, I'm going to put on screen. This is a tweet from Kathy Hochul, governor of New York. Quote, "I would like to point out to the Supreme Court justices that the only weapons at the time were muskets. I'm prepared to go back to muskets. Governor Hochul, get back to me when you've converted your security detail that guards you to muskets. Then I'll believe you."
Yeah, and how about get back to me when you read the actual ruling, when that's addressed in the ruling, and it tells you how the First Amendment and the Second Amendment and the Fourth Amendment all comply now with modern usage. So for her to go back to that just shows me the absolute, it's either the absolute ignorance or the 100% intent to deceive everyone around her to try and get them to believe her.
Yeah, that's a great point. And Mike, you mentioning the First Amendment in particular. I mean, our right to free speech doesn't stop, to just people who can hear our voice without the use of a cell phone or Twitter or some other form of modern technology. Those things didn't exist at the time of the founding. And so if you applied her logic, then the right to free speech would not apply to any of those modes of communication. And you're right that Justice Thomas addressed this issue thoroughly in the opinion that was issued today.
Over on the YouTube side again, Steve says, "Judicial economy, reciprocity was not ripe for decision. I certainly hope that in the future, and let's face it, judicial wheels do not turn quickly. There's not going to be a case the rest of the year and probably next year about reciprocity in front of the Supreme Court. The only case I know of that could get there right now is a case that SAF has with Illinois. And that one is still in the federal district. So we'll see where that goes.
One other thing about the opinion I'd like to mention today, too, is that the court reaffirmed the common use test that was developed in Heller. So they didn't really expand on that test, just right. Simply noted that they were reaffirming that holding, and that in the common use test, for those who don't know, is a test to decide how a court should determine whether particular types of arms should be protected by the Second Amendment. And basically, the test is whether or not it's an arm that is in common use for lawful purposes like self-defense. So something like an AR-15, I think, would clearly be protected by the Second Amendment because it's the most popular rifle in America. And it's used for lawful purposes like sport shooting and self-defense, in hunting and other purposes. So I think an AR-15 would clearly fall within the purview of the common use test. Now, the court didn't opine about how it might apply to certain types of arms, or didn't opine very, very much, but simply said that when those issues come up, text, history, and tradition should be used to evaluate those challenges.
Yeah. And just makes me smile. I'm smiling from ear to ear today, with it. And I think probably one of my favorites so far is when Judge Alito pretty much smacked down New York and said, "Listen, look what just happened in Buffalo. Your law seems, if your law is the best law there is, how come your law didn't stop anything that happened in Buffalo? So your arguments there are not valid."
Yeah, and I like what he said in his concurring opinion, because his concurrence was basically devoted to refuting the dissent written by
Yes.
Justice Breyer. And he said, the dissent cites the large number of guns in private hands, like we're ripe for violence everywhere just because people have firearms. But he says, and I'll just read this, it does not explain what the statistic has to do with the question of whether a person who already has a right to keep a gun in the home for self-defense is likely to be deterred from acquiring a gun by the knowledge that the gun cannot be carried outside the home. And while the dissent seemingly thinks that the ubiquity of guns and our country's high level of gun violence provide reasons for sustaining the New York law, the dissent appears not to understand that it is these very facts that cause law-abiding citizens to feel the need to carry a gun for self-defense. So he sort of turns the dissent's own facts and reasoning on its head and turns it against them. So it's a pretty effective concurring opinion, I think.
And it's everything that we use in our normal talking points every day. Everybody in the Second Amendment industry, these are, and to see them, spoken by these justices now, what we would call the no-brainers, and to see them say it is just so refreshing to see them finally come out again with such a powerful Second Amendment decision.
Alex, I want you to specifically speak to this next comment. Steve says, remember, U.S. versus Miller said common use included military use. I'd never heard of that before. Had you?
I have not. Although, I mean, it would be determined by, obviously, an analysis of text history and tradition, but also what's in common use at the time. So that would be today and through history. So I think, I'm not sure if he's got any particular arms in mind, but I haven't heard that standard applied before.
If that is the case, then I'm going back to, I want my Bradley armored vehicle parked right outside over here, and I want it backed up by a F-22 Raptor out at the airport standing by for me. I mean,
exactly.
And one more here by DJ Play Nice. He says, the wheels of justice turn slowly, but the grind is exceedingly fine. And George says, today's court decision will save lives. Every time, and Mike, you kind of referred to this. Every time we get a permitless carry state, the legacy media and the left are always, the blood's going to run in the streets, screaming, crying, all about all that. We're getting that now, but in a year, 2 years, when the permits start flowing, we're going to get a huge nothing burger other than people being able to exercise their rights. That's what's going to come out of this. Crime is probably going to drop in some of these huge crime areas, but that's about it.
Yeah, absolutely, Paul. And you're right. It doesn't matter what actual facts, what provable facts that we come out with, what statistics. The other side's always going to give you the opposite statistics, because they're people. Again, it's not about truth. It's not about integrity with them. It's about winning, and they're insisting on winning at any cost. Integrity be damned.
Yeah. I think it's interesting that with rights so fundamental as the right to keep and bear arms for self-defense or for any lawful purpose, until now they've been treated like a second-class right. I mean, right? You hear that phrase thrown around a lot in the gun rights community, especially. And the court today says that the Second Amendment is not a second-class right, and it shouldn't be treated any differently than the right to free speech or the right to be free from search and seizure or the right to remain silent. It should be treated as a fundamental right, and the court said that clearly today.
All right. Well, and as I expected, we're going to go a little long because we are at time right now. But I want, at the very least, I want to get. We had a press release come out just a little while ago from SAF, from my boss Alan Gottlieb. I want to read a little bit of this. We'll discuss it, and then we'll close things down. But the press release starts off: today's ruling by U.S. Supreme Court striking down New York's good cause requirement to obtain a carry permit is long overdue affirmation that the right to bear arms exists outside the home and always has, the Second Amendment Foundation said. We are gratified that the High Court has said there can be no bureaucratic prerequisite to exercising one's constitutionally protected right to bear arms, said SAF founder and executive vice president Alan Gottlieb. For too many generations, New York's requirement has been the vehicle by which constitutional rights of average, law-abiding citizens have been deprived under color of law. I'm going to skip down a little bit. The SAF congratulated New York State Rifle and Pistol Association for its victory and for its daunting determination to see this battle through to its conclusion. This case was only allowed to be brought because of SAF's 2010 Supreme Court victory in McDonald versus the City of Chicago, which overturned that city's handgun ban and incorporated the Second Amendment to be applied to the states through the 14th Amendment. Then finishing up, this is a clear victory for the Second Amendment and law-abiding gun owners, Gottlieb said, and a staggering defeat for the gun prohibition movement and their billionaire financiers. Elitists who have their personal armed private security have no business trying to undermine the rights of less privileged citizens whose lives are just as important. Whether gun prohibition forces lose, average people win, as they did today. Whenever gun prohibition forces lose, average people win, as they did today. My boss says it better than I can, so.
He's pretty good at those releases. Yeah, he's got some good statements when it's time to put them out.
Yeah. This is what we've been waiting for. We had oral arguments back in early November. And it took now it took 6 months, 7 months for that decision to get here. So, this feels, it's certainly a victory, but the one other thing that I want to touch on before we go off is, it also is kicking the other side. They're not just melting down on social media. They're kicking off in high gear. Schumer has said they could have a vote in the Senate today on the gun grab, on the anti-gun bill. They are pushing everything forward at light speed on the other side. So, if you haven't today, I again called both of my senators today. If you haven't yet, there's a number, 202-224-3121. And it's past, it's 6:33 on the East Coast, so you'll have to leave a voicemail. But if you're on the Mountain or West Coast, you can call their local offices in your state for your senators. But still, call. You need to be getting your senators your opinion that this whatever they're called, they've got a great name for it, but this anti-gun bill going in the Senate, we've got to get this collared.
And I saw that Todd Young was one of the Republicans. He's from Indiana. He was one of the Republicans who recently joined in support of advancing this bill. So if you're from Indiana, light up his phone, light up his email, let him know that you expect him to stand for freedom and for the right of the people to keep and bear arms, and that these proposals in Congress are not going to do anything to advance freedom.
And I was looking yesterday. Isn't he up for re-election this year?
Yes, which is which is interesting because we talked the other day about the 4 Republicans who were retiring and came out in support of the gun control legislation, which shows their true colors. But yeah, he's up for re-election. He's not one of the senators that's 4 years out. He's facing the voters this coming fall. So let him know that you're going to hold his feet to the fire, and expect him to stand for individual rights.
All right. Let me go back to comments, because going back to that Miller versus U.S., I want to get this one up. Steve commented again. He said Miller's sawed-off shotgun was banned by default because there was no evidence of military use. That's something I'll have to look into, maybe bring it up on another show when Alex is on. And then Michael says, to quote Mark Twain, there's lies, damn lies, and statistics. And the other one I like is that liars figure and figures lie, so... And one more from DJ Plain Ice, U.S. Senate contact page. If nothing else, I would prefer you call them, because that ties up their staff, and their staff have to mark it. But you can always email your senators as well. So,
Paul, one thing that I do, and I tell everybody to do also, is don't just call your senator. Call the House of Representatives, call your congressperson, call your governor, call your city council, call your state representatives and your state senators, and lean on them. Because if you can get them to lean on your senator, that's big money too. Because you as an individual, you call, that's huge. That's a big thing. You get your governor to call that senator and say, listen, I got 5 million people here calling me saying, what are you doing, knucklehead? That's huge as well. So I like to lean into all of them to pressure the senator when it's time.
All right. Let me see here. Oh, wow. I do want one. Maybe we'll tell you what we're gonna, because we're already long past time. So I'm gonna go ahead and I'm gonna shut this down, folks. I would encourage you. Tomorrow is Training Friday. Come join me as Tom Walls and I have a training topic. We haven't picked it out yet, but we will talk about a training topic tomorrow. On Saturday, in the weekend edition at 12 noon, we've got, and you've seen these folks all together before. It was an awesome show. Charlie Cook, Tony Simon, and Beth Alcazar are all joining me for the Saturday show. Going to be a great show for that one. Join us then. But for today, folks, I think I am going to shut it down. Thank you so much for watching, and we will see you next time.